Okay, so we are talking about a very interesting subject.
Yes.
Um, it rarely ever comes up. It's off the wall. It's completely exceptional. So why don't you tell the viewers what it is that we're talking about?
Okay, so we're talking about a recent Ontario Court of Appeal case that has come out. In fact, I'm just looking here to see the release date, but it was released September 20th of 2021. And the parties' names are Jurians, Lauer, those are the judges. The parties are Blacklock and Tzak, T-K-A-C-Z, if anyone's looking at spelling it. I can actually, if anyone wants to look it up and they're curious, the citation is 2021 ONCA 630. You can find it on the legal database CanLII. But it's a decision involving the issue of retroactive child support and a claim brought against a payor's estate after he passed away for retroactive child support that he had not paid for his two children.
And how old are those kids again?
They are old. They're like born in 1973, I think, or maybe even longer than that. The children were born in 1970 and 1972. So
They're in their late 40s, early 50s.
yeah, they're almost as old as me. So can you imagine can you imagine if my mom was still around bringing a claim for child support against my father's estate for me?
Isn't that shocking? So first of all, let's actually make it clear to the viewers what actually happened, and then we'll talk about what the court's decision was. So what happened was a couple split up about 20, 30 years ago, and when they split up, the children lived with the mother. Nothing particularly odd about that fact scenario. Then what happened as part of their divorce settlement was there was a court order, a divorce order, also particularly common. And in that court order, it said the dad was to pay mom a certain sum in child support. Still completely common. What was also common back then was the amount of child support was this much. It was $20, $20 a month per child, right?
Can you imagine?
So I don't know how far 20 bucks went 30 years ago, but I could only imagine that if somebody were to receive $20 a month in child support right now, it would not go very far. In any event, common or not common, it doesn't really matter. That was the amount that the order was for. The order was made under the Divorce Act. In Canada, you can get child support under the Federal Divorce Act, or you can get it under the Provincial Family Law Act. In the Blacklock Tzak case, it was paid under the Federal Divorce Act. Fine. Still nothing particularly uncommon. Then the kids grew up. They probably went to university. They probably got married. They themselves probably have children, possibly even themselves have grandchildren. That I don't know. I made that up. But the fact of the matter is, those children are no longer children. They're adults. And their father died a couple of years ago. He dies, and the mother, who was now 20 plus years divorced from her ex, sued the executor of her ex-husband's estate for retroactive child support by claiming that for many years he underpaid child support many years ago. Well, when she brought a motion before the Court of Ontario asking to reopen the divorce case in order to determine that the man before he deceased underpaid child support, and so therefore there should be a child support adjustment that is then paid by the estate of the deceased former father, former husband, the court said, not happening. Not on our clock. You've got lots of problems. And of course, they didn't say it the way I'm saying it. They used very fancy legal language, and they reached their decision based on very strong legal principles. Now, you would think that this elderly woman would have said, I gave it a try. It didn't work. I'm going to give up. She went to the Court of Appeal and she asked the Court of Appeal to reverse the decision. Court of Appeal said, we're not doing that. The decision that was made by the lower judge was the correct decision. We're not going to change it. Anyway, so those are the facts of the case, which I find particularly startling. Not all the ordinary stuff, but the extraordinary stuff that I've just mentioned. But now let's talk about what is the legal basis for that. Now, Leanne, did you have a chance to read the case recently?
I did, yes.
Why don't you tell the viewers what the legal reasons were?
Well, essentially what it boiled down to is the court said that it's been a long-standing principle that if someone has a support obligation under, under the Divorce Act, that if the payor dies, that's usually a ground or a reason why support payments end. In fact, we see that in separation payments, say support for the child ends when one of these situations happens. Often one of the things listed is that the payor dies. That's just a common thing. And because it wasn't explicitly said that the estate was bound by this with the support obligation if the payor died, the court ruled that this long-standing principle that the payor dies, the obligation that's what comes into effect here. That's what's at play. There was nothing saying otherwise in the order or in the I guess it was an order rather than a separation.
It was a divorce order.
Yeah. There was nothing in the order saying, binding the estate or saying, that it could be brought against the estate. So the obligation was done. So if she had brought this before the payor died, that might have been a different scenario, although I personally haven't seen people going after retroactive support for children that are, in their 40s. But because the issue really was that because it was brought against the estate after the payor died, and there wasn't something in the order binding the estate, that she was out of luck to be bringing that claim.
So one of the reasons why I love being a lawyer is because I love occupying the same space as very smart people. And the judges at the Court of Appeal are some of the smartest people that exist certainly in all parts of the world, but definitely in Ontario. And so the decisions they make and reach are not necessarily gut instinct or common sense. It must be grounded in legal principle. And the decision that was made by the lower court and then by the Court of Appeal was entirely grounded in the legal framework. And so what the judges all said was that the woman brought an application under the Divorce Act to change child support from the past. And the problem with it is the Divorce Act does not allow somebody to get child support out of an estate. Okay, fine. The Court of Appeal was very polite, and they said, had she actually asked for this under provincial legislation, well, she could have, because the provincial legislation called the Family Law Act specifically says that child support is to be secured by the estate. So whereas the Divorce Act by the federal government has not provided for security from the estate of a deceased payer of child support, the provincial Family Law Act does allow it. Now, that was a very polite thing for the Court of Appeal to say, because I think at this point, that woman is not going to bring a new application under the Family Law Act. But if she did, I think there is not a chance that the court will now reopen this case by allowing her to do the same thing under the provincial legislation that might allow the claim to be made. Neither the lower court or the Court of Appeal really went to give an opinion on the merits of her case. In other words, they shut the case down on legal principles. They didn't say, well, assuming she actually had a legal foundation then we would dismiss the case for factual reasons. They didn't go that far. But in my opinion, for what it's worth, she would never have been able to ground a case in this situation for child support for children who are in their 40s and 50s on the basis that their father, who is now dead, underpaid child support 30 or 40 years ago. That's just my opinion. But let me just continue with the Court of Appeal, with this subject matter from the Court of Appeal. We've got a higher level court to the Court of Appeal. Leanne, for the viewers, who is higher than the Ontario Court of Appeal?
Well, the Supreme Court of Canada. And I don't think, do you know, did she appeal to the Supreme Court of Canada?
No. Where I'm going with it is that in the same year, this year, we have another decision from the Supreme Court of Canada on a very similar topic. And I think we may have discussed upon this before. In the Supreme Court of Canada decision, I think it's in May, of Colucci and Colucci, that was a situation where while the children were still young, the father had underpaid for something like 16 years. And the mother went back to court and said, I want 16 years of underpaid child support. And the father said, wait a minute, 16 years? You're going to bankrupt me if you go back 16 years. And the Court of Appeal, Supreme Court of Canada said, oh, if you owed that child support and you underpaid and you had an obligation to provide proof of your annual income, and that annual income would have resulted in higher child support, we don't have any sympathy for you. You, Mr. Payor, have to pay the underpaid child support, even though it goes back 16 years. So that's an interesting juxtaposition between the Blacklock case and the Colucci case, because as crazy as the Blacklock case is, there is very strong legal principles espoused in the Colucci case by the Supreme Court of Canada that basically says child support is the obligation of is the entitlement of the child. Pardon me. It's the entitlement of the child to have that child support paid to whoever the parent is that's caring for them. And when the person that's supposed to pay it to the person that's supposed to receive it doesn't happen, that person is not off the hook, and they've got to pay it.
Well, it's interesting because before Colucci, the cases seem to say that if the recipient hadn't been requesting it, the courts tended to go back, from what I had seen, 3 years or so, but it wasn't going back like 16 years. And Colucci came out very, very strong, just what you said, Steve, that it is the right of the child, that just because the mom or whoever it was that was entitled to be paid this child support didn't make the claim or didn't pursue it, didn't ask for those tax returns that they were supposed to be receiving every year, it doesn't mean that they can't then go and claim it years later. I wonder though if the children in Colucci were, my recollection is they were university aged, or they might have been.
Yeah, I think it was they were adults, but there may have been Section 7s going on or whatnot. But Colucci didn't go so far as to say that they need to be economically dependent children.
Yeah.
I think it was still within the zone.
Yeah.
And the zone was not like in the Blacklock case. That zone was way past.
I'm wondering if in Colucci, if they had been in their 40s, whether, the court would have gone that same way, or whether they would have found some reason to bar it. There has to be, I don't know, I would think there has to be some point in time where, from a practical standpoint, I don't know of a legal principle or a case that would speak to it, but there has to be some point in time where, I would think somebody cannot bring that claim. I mean, if the child is in their 40s.
Yeah. And that's the nature of law. So, when people ask me, what does the word common law mean? Well, the word common law just basically means it's judge-made law based on gaps in the statute. So when there's a statute that says this must happen, people don't go to the courts to seek a judge's interpretation of that. But where there's some gaps in it, the courts get involved. And so prior to Colucci, and for at least the last 10 years, we had DBS. In the DBS case, which went to the Supreme Court of Canada, the court said indirectly that a recipient of child support can go back 3 years to review child support unless there has been culpable behavior. Blameworthy conduct was the actual language. So unless you can prove that somebody was deliberately misleading, the payor was deliberately misleading the recipient when it came to child support, the period going back was capped at 3 years. And so when it went to the Supreme Court of Canada with Colucci, the Supreme Court of Canada had an opportunity to correct itself and to clarify that they never really meant that you could not go back, and they never really meant that once a child is an adult, that the recipient spouse is not allowed to go back. And that might be, now that I think about it, that might be what caused Ms. Blacklock to go back to court, because maybe she read Colucci from May and thought, hey, wait a minute. The Supreme Court of Canada said there's no cap on how far back you can go. I bet you if we interviewed her, we might find out that maybe that's what drew her out and drove her to want to seek this retroactive award. Now, by the way, I just want to say, for those viewers that remember our former esteemed mayor of North York, Mel Assman, well, years after former mayor of North York, Mel Assman, stepped down from being the mayor, and he was, by the way, a esteemed, revered, loved mayor of North York, it became evident that while he was married and had children of his own, he had children with another woman. And that woman decided to out the mayor and to go to court. Actually, it was the children that went to court, the adult children, to seek support from Mel. And Mel pulled out an agreement that was signed with that woman that he had kids with, whereby I think it was $16,000. He wrote a check for $16,000 lump sum, and he settled child support. And they were trying to overturn that and seek significantly more in retroactive child support, and the court shut that down back in the day. So
I remember I wasn't practicing family law, I don't think, at that time, but I remember reading about it in the news when Mel, that was quite scandalous at the time.
So some people believe that Toronto is very black and white, very boring. There's not much going on here. All of the action is in LA or in Hollywood. Not true. There's a lot of family law action locally here in Toronto with very interesting cases, presenting us with tremendously wild fact scenarios. And the one for today was very old woman sues estate of ex-husband for child support and fails.
Well, and on that note, I think we'll wrap it up. This was an interesting case, and I think, it's very fact specific. Like, I think that, well, it's not fact specific. It goes the principles.
No, you're right. I think it is fact specific because we don't really know if she was younger, just like Colucci was a little older.
Yeah, true. We don't know if the kids had been, younger age, whether the result would have been different. But I think the actual decision itself and what it's referring to with respect to the Divorce Act and versus the Family Law Act and the legislation there, I think that's a very legal decision rather than fact specific. But it would be interesting if she did decide to go and pursue it the other way, what would happen. But I noticed she got dinged for $3,000 in costs in this decision, the Court of Appeal decision. So she probably doesn't want to have to incur any more costs fighting it. So thanks as always, Steve.
Pleasure chatting with you, Leanne. We'll catch you next week.
And we will see you here next week. Bye for now.
Got it. Take care, everybody. Bye-bye.